Hello and welcome to the lectures for Indian polity. So we are discussing our is this class 2. We are discussing Indian polity. So we have started with constitutionalism. So again, I am saying that all these topics are just as are for small basic understanding. They are not like actual topics. Actual your content would start from here historical underflings. So only 2 3 paragraph are there. So we will start the actual topics which are actually mentioned in our syllabus. Till now we have only discussed the basic thing about the subject, that what is the meaning of the name of the subject. Okay, so we are discussing constitutionalism. So what do you mean by constitutionalism? See, whenever you find ISM after any word, it becomes a certain thought, a certain ideology, certain stream of thought. For example, we have liberalism. Okay, so ism is there, isma is there, so it becomes a thought, a stream of thought. We have socialism, it is a stream of thought. Like that way, there are so many thoughts, so many streams of thought are there. So what do you mean by constitutionalism? So the very basic meaning of constitutionalism is that the government or any authority who is ruling over the people, that authority is limited, is bounded by the constitution. This is the meaning, simple words. It means it cannot breach the constitution, it cannot violate the constitution. A political philosophy based on the idea that government authority is derived from the people and should be limited by a constitution. See, the government authority is limited by the constitution. It means the government or any authority who is exercising power over the people, it cannot violate the constitution. The concept of constitutionalism incorporates the principles of limited government and rule of law. Again, new keywords are there. What do you mean by limited government? See, two keywords are there, limited, another one is government. We have already seen what do you mean by government. Any entity or organization which is governing over the people, it is government. What do you mean by limited? Limited means the thing which is limited by another thing. So limited government, it means government is limited by other thing. And what is that thing? It is constitution. So government is a limited government. Why? Because it is limited by the constitution. Rule of law, we have already seen that there is not a rule of person, there is a rule of law. And which law? The constitution. It means constitution will prevail, your personal ambition will not prevail. The constitution, the provision of the constitution would prevail whenever there is a conflict over the personal interest of the ruler versus the provision of the constitution. So the provision of the constitution would prevail. So the philosophy of constitutionalism is based on these two things, limited government and rule of law. Okay, so it implies that exercise of political power shall be bound by limitation, checks, controls and rules. See, limitations, again it is by the constitution, checks, it is by the constitution, controls and rules, all these by the constitution. This arrangement forces the rulers to stay within the jurisdiction by means of a written or unwritten constitution. So basic thing, again the concept is the same, that government or any entity, any organization which is ruling over the people is limited by the constitution, in simple words. So this is just a theory portion. Any country that has a democratic governmental system is an example of one that is limited government. Okay, so this is an example of limited government. So we have democratic government in India, so we are having a limited government because we are also having a constitution. That's why we are having a limited government. Another examples are USA, England, Australia. Okay, so there is another new word, that is written or unwritten constitution. So again, when we will study the topic of amendment of the constitution, the basic structure of the constitution, these two are different topic in our syllabus. So where there we will study these things, that what do we mean by written or unwritten constitution. Right now the basic thing is that in written constitution, what is the difference written versus unwritten? The very basic difference is that for written constitution, certain entity, certain organization or certain assembly was there which created the constitution. That is the simple explanation. See, written or unwritten does not mean that in written constitution we are having a book in which certain provisions are written. No, this is not the meaning. The meaning is certain assembly or certain organization or entity, certain authority created the constitution at a certain period of time. It is called a written constitution. But in the case of unwritten, this is not the case. It means certain authority or organization did not created the constitution at a certain period of time. So how the constitution was created in the case of unwritten constitution? The constitution, how constitution is created? By the conventions, by the laws, by the judgments. It means there is not a particular body or authority which sits in a particular place at a particular time to create the constitution. By the time, by the month, by the days, by the years, as the time passes, certain laws the legislature makes, certain judgments the judiciary passes. Based on those laws and judgments, the constitution comes in the place. Okay, so it is the result. The unwritten constitution is the result of the different laws, different rules and regulation and judgment passed by the legislature or the judiciary, or even different executive actions taken by the executive. We have already seen these three organs: executive, legislature and judiciary. Again, this is a separate topic in the separation of power topic, so we will discuss in great detail what is executive, what is legislature, what is the difference, what are the similarities, what are the issues, what are the conflict. We will discuss from the perspective of both prelims as well as mains. We will discuss although the previous year papers also. Okay, so this is the difference of written and unwritten constitution. So again, these are the components of your constitutionalism. Rule of law we have seen, the provision of constitution would prevail. Separation of power we have seen, the judiciary will adjudicate the law, it will provide justice. Legislature would create the law, make the law, and the executive would implement the law. So this is separation of power. Free press and media. See how constitutionalism is based on free press and media. How? See, let's say we have certain number of media organization and the government has control over them, or even the certain private entities, some business owners, they are having control over those media. And let's say certain event happens in certain part of our country. Now media is going to report, but the government has control over them, so it will report only those things that the government allows. It means the media is biased, it is not free, it is not neutral. So constitutionalism will not prevail, isn't it? So this is the component. Independent judiciary, we have seen that the task of judiciary is to adjudicate the law, isn't it? The task is to provide justice. But if the judiciary is not independent, how would it provide justice? For example, let's say the salaries, the functioning, the working of judiciary is in the hand of the government. How would judiciary would provide justice? It cannot. So judiciary has to be independent, and there are provisions in the constitution related to the independence of judiciary. It is also a different topic in our syllabus, so we will discuss it there. Another is elected government. It means, see, government has to be elected, then only people can hold it accountable, isn't it? For example, we have elected certain government, certain political party in power. Now that political party or that government is not working according to our requirement. So in the next election we can change the government. So the government has to be elected. Now constitutionalism in India means what are the provisions in India that ensures constitutionalism. So all these are provisions. Written constitution we have already seen. We have written constitution in India because constituent assembly in India created our constitution. Responsible government we have seen that we have elections. So government is responsible and accountable for the people. We have parliament. So government has to give answers to so many questions in parliament. Whatever policy and schemes it makes, it has to give answer in the parliament. Parliamentary democracy, we send our representative. See, again this is a another separate topic, parliamentary democracy, because two keywords are there. One is parliamentary, another is democracy. We have democracy. There are so many types of democracy. One of them is parliamentary. In simple words, what do you mean by parliamentary democracy? There has to be a parliament to exercise democracy, to implement democracy. Simple words. So what do you mean by parliamentary? What happens that people elect their representative, and those representatives take part in the parliament to discuss or debate certain subject matter which concern the people, or to take decision which concern the people, or to make policies for the citizen or people. So this is parliamentary democracy. Then rule of law we have already seen. Fundamental right, again it is another topic. Separation of power we have seen. Flexibility of constitution. What do you mean by flexibility? The flexibility, it is in the sense of amending the constitution. It means whether the constitution can be amended easily or it is very tough to amend the constitution. So our Indian constitution is flexible. It means it is tough as well as easy. So certain provisions which can be amended easily, certain provisions which cannot be amended easily. So our constitution is flexible. What is basic structure? Again another topic, separate topic. See, basic structure, it is a term given by the judiciary, by Supreme Court, 1973, Keshwanand Bharati case. What do you mean by basic structure? See, basic structure is decided by the judiciary. It means judiciary will decide what constitute the basic structure of the constitution. So the basic definition is that basic structure means certain values or certain principles are foundation of constitution which cannot be changed. Now what are those certain values or principles? Who will decide? The judiciary will decide, that too on case to case basis, not in a one instance or in a one case. No, each and every individual case the judiciary will decide. So this is basic structure. Now there is federal form of government. What do you mean by federal form of government? We have already seen at least two tiers or two levels of government has to be there. Independent judiciary we have already seen. Judicial review. What do you mean by judicial review? So again, review by the judiciary. Review of what? The act of executive or the legislator or ठीक है? Okay. So this is the concept of judicial review. Means the judiciary reviews the act done by the executive or simply the government or the parliament or the legislature. This is judicial review. So the concept of constitutionalism has been recognized by the Supreme Court in Rameshwar Prasad versus Union of India case. Okay, again this is a factual detail for your mains, that if question comes in constitutionalism you can quote these cases, because whenever you quote Supreme Court's related cases and their judgment, you give weightage in your answer. So this is just only factual detail and theory portion. So now your actual content start. We will discuss it in next class.